Mr. Cedric Fu.
Before I speak on this bill, Mr. Speaker, thank you. I'd like to comment a little bit on what Walter talked about. I think as a member of the House, I too appreciate and support free speech. I too support the investigation of ideas, the exploration of new ideas and so forth. And I believe that if there is indeed a Galileo today in Singapore, we'll all be cheering rather than stopping what he's doing. The bill was met with quite a lot of discussions. It's actually not that complex. And while there are many discussions about what's truth, is it epistemological truth, is it David Hume's version of it, is it evidence before the courts? But fundamentally, we have a real practical problem. That's it, which is facing us, and we have to deal with it. And rather than tinkering with the separation of powers in the state, be it elected members and the party having the largest member forms the government, and separating this executive power with legislative power and judicial power, and we modified that with presidential powers. To tinker with this, I think just for the purpose of this bill, is quite dangerous, and I think all parties should give deep thought to whether or not we should introduce another layer of power structure, which the NMPs call the Independent Council, to oversee the government, where ministers supported by civil servants is already elected, already have a mandate to make sure and ensure peace and order in the society, and is always accountable for their actions in this bill to a judicial review or statutory appeal. But more importantly, every 5 years at the ballot box. Would an independent council be subject to that? I think we need to think carefully before we decide which direction to take. But it is very heartening that most MPs who have spoken agree that fake news is a real problem, and we need to deal with it, especially when public interest is at stake. As I understand, listening to Minister Shanmugam, this bill applies only on 2 conjunctive conditions. 1, falsehood, but that's not good enough. 2, public interest is harmed. So the part of the public critique and comment and criticisms that doesn't impinge on these 2 would be free to flow as they have been. But the disagreement seems to be who should be the decision maker. Should it be the executive branch, which I interpret as the minister supported by the civil service, or the courts, or a separate council? Now I understand from the NMPs that the separate council is not the party who will make the decision whether whether an issue is true or false, but to be a review committee over and above the executive branch decision. I don't see where they get the mandate to do that. So there can be 3 possible areas, bodies to be decision makers. So let's see which makes the most sense. And to answer the question, I think it is important to know that 1, we all heard of the words gone viral, and fake news that gone viral and yet undermines public interest has to be dealt with very, very quickly. So speed, I think, is the first criteria to judge whether executive branch is best placed, the judiciary is best placed, or independent counsel to overlook is best placed. And we have heard many examples that's been discussed here. I will just point out 2. In March this year, videos circulating on Facebook, Snapchat, etc., claims kidnappers in vans are adopting children for prostitution and illegal organ trades. And this happens in the French area. And the accusations were made, falsely of course, of the French Roma community or the Gypsies. The Gypsies were attacked by unprovoked vigilante mobs, even though this rumor is totally false and baseless. 2 men from the Roma community were hospitalized, their van burnt. Another example in Medan, Indonesia, in July 16, a woman complained about the use of loudspeakers at a mosque near her home. But rumor has it then, fake news, that she also threw items at the mosque and disrupted prayer sessions. And this led to, again, incited angry mobs who started burning and ransacking Buddhist temples with damages running into billions of rupiahs. So a lack of speed, and these are the consequences. The second criteria, I believe, is the issue on accountability. If the government is elected and the party with the most seats in parliament forms the government, they have not only the mandate and responsibility, they have the accountability to make sure that public peace and social stability is at all times preserved. Now, it also has the resources, being backed by the civil service and the expertise in many, many domains, whether it is medical, security, health, water, and falsehoods can be quite insidious in any one of these areas. And I really don't see another institution in Singapore which has this wide domain of expertise in many, many domains as I described. So, in management science, it is logical that the person who is held accountable and the person with the resources and the expertise must be the party who should act. And so I believe and I support that the executive branch, supported by the civil service, should be the right party to act. I also want to point out that in the Select Committee report, there was a recommendation number 12, and I have an excerpt here. And in it, it stated that the new legislation, talking about POFMA, will need to be implemented to combat online falsehoods. And such legislation should have the following objectives. And prime among them, number one, the measures will need to achieve the objective of breaking virality by being effective in a matter of hours. I'm quoting the Select Committee report. And I would also want to point out that Mr. Pritam Singh is a member of the Select Committee report, and the committee collectively agreed that whatever law is legislated and whatever measures we put on the decision maker, it is very, very important that actions must be able to be taken in a matter of hours. And I think just yesterday I heard Mr. Singh debating on the POHA bill, and he was basically saying that if an aggrieved party wants to have an expedited protection order and so forth, would the court be fast enough? So I see a contradiction of why the Workers' Party is supporting the judiciary as the party to make such orders in the case of the POHA. Also, as a member, the Workers' Party's leader in the Select Committee, agreeing to recommendation number 12, that whichever party that is to be made the decision maker must be able to act in a matter of hours. Also, there was a para in the Select Committee report, paragraph 364B, where Associate Professor Goh Yi Han, Dean of the SME School of Law, was a proponent of the executive option. So he's a learned man in the School of Law, and he supported the executive options, which means that the government, the minister, supported by the civil service, will be the party making such decisions. And here again, I want to quote what the report said. Associate Professor Goh explained that the judicial process, while important, may not be sufficiently fast to deal with the rapid spread of online falsehoods. Court processes require an application for a court order to be made together with a supporting affidavit. The application must then be served on the person against whom the order is sought, and that person can then file an affidavit in reply. So the court may require a hearing before coming to any decision. So there are eminent and learned persons who support the executive being the decision maker. But to be fair, there are also some representatives at the Select Committee who were skeptical of the executive action. But they too, and I quote from the report, also accepted that there are situations such as those involving public order, national security, and workings of public institutions, where only the executive, and these are the skeptics who are representing to the Select Committee, where only the executive would hold the facts, and where the facts should be backed by the authority of the executive. So I assume the whole machinery of the civil service supporting it. So I think, but while POFMA is to empower ministers and civil servants to act, of course the court is empowered as the final arbiter of truth. But actually, to think about it, at the end of the day, the ultimate arbiter of truth are the voters at the ballot box. Really, the court of public opinion will be the final judge of whether the government has done its job well. So I am less excited about the idealism or the imagined complexity, or some may say the falsehood around the POFMA bill, than the practical need for us to act quickly against a very real, present, and very critical problem, fake news. Thank you.
Mr. Pritam Singh.
Thank you, Mr. Speaker. I had stepped out of the chamber, but I roughly heard Mr. Cedric Fu's comments. Just to be sure, so that I don't misquote him, I understand his two main issues were that I was part of the Select Committee, and the Select Committee recommendation was that quick action was important, response time within a matter of hours. That was the first. And second was, yet yesterday during the POHA debate, I asked whether courts could be fast enough. Let me deal with the first issue. Actually, I'll deal with the second issue first because that's more pertinent. We found out during the POHA debate yesterday that when there is an issue affecting an individual or company, there is an easy there is an easy form to fill out, or at least this is what the minister assured us, for individuals or companies to take action to deal with online falsehoods quickly. And let's remember, virality is not an issue that only affects the government. It also affects individuals and companies. And we know that there was a reference made to making that process more straightforward, streamlined, easier. And I used an example during the POHA debate about a matter that was brought up by Minister Shanmugam on the 13th of April in a Channel News Asia interview, where he said that you can have a situation of a company, falsehood has been launched against it, and in 4 or 5 hours, billions of dollars could be lost. Now, if individuals are expected to rely on the harassment courts for quick remedies, it is my position that we can expect a speedy response to come from the courts. Of course, it would mean raising the courts to be able to deal with those problems. That I can concede, that you would need courts to respond quickly. But it does not contradict my signing off on the Select Committee report on an option to ensure that the response is a speedy one. Because I believe that the courts can respond speedily, and the expedited timeline or an appropriate interim order can deal with a prima facie falsehood. That means the case the government brings to the court, the protection from harassment courts, is this is prima facie. Questions of having to sift through evidence really turn on how real the issue is, and the prima facie nature of the threshold should deal with that issue.